Hello and welcome back to the channel again. There was a huge chaos around the community among all the applicants. The Italian government introduced an emergency decree, the so-called decree law, the decree law 36 of 2025. So basically they introduced new regulation, new restrictions about the new application, the future applications for Italian citizenship by descent, Italian citizenship jure sanguinis. Everybody talk about the text, but nobody says what you need to do, because you can say, okay, I understand the text, but what do I have to do? Can I still apply it? Do I need to wait? Today we want to cover all these questions. This is Marco Bersani as always from the Bersani Law Office from Italy, an Italian immigration law firm with expertise on Italian citizenship applications. So do not lose any more time and let's start. So let's start very quickly on the decree law. At the current moment, you know that since March 2027, the government basically approved a decree law 36 of 2025. The decree law is like an emergency decree. In some ways, it's like, you know, the executive orders that from the presidents, you know, for example, in the US system. So it's like you bypass the parliament and so you make an emergency decree, an emergency decision, regulation that is immediately in place because it's based on random emergency situation. Of course, this is one of the most controversial points of the Decree Law 36 because, of course, it's very unlikely that we can talk about an emergency situation. Is the number of people applying, the huge number of people applying for citizenship by descent, a national emergency? Maybe not. But what is really important today, beside all the legal opinions, the legal consideration, as I said, today we want to focus on giving you some concrete answer to your questions. So what you need to do now, what you should do now. So let's proceed to explain the type of situation, the type of scenario, and so what you need to do. So the answer to your question. The first situation is the situation where you have a typical case, administrative case, so a case that can be processed normally by an Italian consulate. You know that right now it's actually almost impossible everywhere. US, in Canada, in Australia, in South America, in United Kingdom, in many other countries, to basically have an appointment because the consulate are overwhelmed with application, so they are fully booked until 2028, 2029, some cases, or simply because they basically stop to take new appointments, and so they make it impossible to you if you connect on the website, to the pre-notomy website to get your appointment. It's basically impossible. So it's like winning a lottery. What is important here is to consider that, or because you are in a waiting list, or because you are unable to get an appointment, it means that your application is already ready to be processed before the new decree law. In this situation, well, your application, in our opinion, must be processed under the old rules. So under the rules that we all know, so the rules before the decree law 36. Why? Because you ask to file your petition, you ask to file your application, so to claim your right before the Decree Law 36, so before March 27th. So if you fall under this situation, we think that you have all the legal basis to file your case, of course, through the legal system, through the court system, because of the lack of appointment. And additionally here, what we can do is to show, of course, we need to show it to the court that you tried in the past to, for example, to make your appointment. So for example, you can have some screenshot you took in the past showing that you tried to get an appointment, but the appointment was always showing you a pop-up notification says no appointment available. This is very important because as long as you can show an evidence and you can prove that you tried to make your appointment before the Decree Law 36, then you might still be able to claim your Italian citizenship by descent under the old rules, under the old regulation. Another thing about these scenarios, which is for all the scenarios, it's a common legal consideration. You know that the right of Italian citizenship by descent is based by jure sanguinis. What does it mean? By blood. When you were born from your father or mother on the Italian line, When you were born, you got at your birth, at the date of your birth, in that moment, you got by blood the right of Italian citizenship. So this is a consideration valid for everybody. So for who is going to apply to the consulate but go to the court because of the lack of appointment, but also for the 1948 cases. You got your right of citizenship at the moment of your birth. So if you are born before the decree law, so almost everybody, then you can still apply under the old rules because you already got your right of Italian citizenship by descent at the moment of your birth. At the same time, we can focus on the second scenario. Let's assume that you have a lineage and you cannot apply through the local Italian consulate because you have a 1948 case. I have my bloodline like my great-grandmother, grandfather, and grandfather was born before 1948. So you have a female on the bloodline, a female who had a child before the year 1948, before the Italian Constitution took place. So here also we think that you can still apply for two main reasons. The first reason is that, as I said before, you got your right of claiming Italian citizenship by descent by blood at the moment of when you were born. In that moment where your mother, your father gave birth to you, then in that moment you got by blood, this is the principle of the definition of jure sanguinis, you got by blood the right of claiming by blood the right of claiming Italian citizenship by descent. This is one of the reasons. The second reason is the legal nature of the 1948 cases. You know, maybe if you don't know it, I mean, we suggest you watch some videos that we publish about the 1948 cases to explain what type of cases they are. These type of cases are so-called exceptional cases. These cases are not set by the law. These cases are only set by the jurisprudence, only set by the courts. Why this is relevant? This is relevant because the decree law and any reform by law, if they don't have an express referral to 1948 cases, they cannot touch 1948 cases because 1948 cases are not set by the law, but are set by the court, only by the jurisprudence. There was never a law regulating the 1948 cases, and that's why you cannot go through the consulate, because there is no law regulating the 1948 cases. So if the decree law, and so the new law, the 2025 law, doesn't specifically touch the 1948 cases, then the 1948 cases are, they call it in extra legem cases, so out of the law. So the decree law only touches the law and the old laws regulation, and so they cannot touch the court cases, and so the 1948 cases. So our advocacy is very, very clear. You can still, and you have to still challenge the new cases with the court. That's very, very important. It's very, very important. You have not to give up. We also wrote a very long, detailed article with also all the frequently asked questions we are receiving since this month about the new regulation, what I need to do. So you can find the description below here and also here in the link. You can find a link to the article that we wrote about it, so if you want to read it. It's very interesting, but at the very end, what is really important is that our advocacy is very clear. You have not to give up, not to give up. You need to challenge the new regulation. Also because we are pretty sure that the new regulation will be also challenged not only through the ordinary courts, but also eventually through the Constitutional Court, because this decree law and the future law that will be, we think, the same as in the text, with very, very little changes, but very in some ways not relevant changes for most of the applicants. There are also some constitutional concern about this decree law, about the new law. And we are not just saying it, so we are not alone saying it, but if you read all the paperwork with the Italian Parliament where there was the discussion about the decree law for the conversion to a law, you see that there was some other professor for universities in Italy about constitutional law, that they made a clear statement explaining why there are some constitutional concerns. So this is not our only opinion, but we think that is also an opinion of many attorneys in Italy and also by professors of constitutional laws that they made some relations explaining all the legal concern on the constitutional side about this new regulation. So we are pretty sure that these cases can be challenged. But anyway, as we said, we think that you still have the right of claiming your Italian citizenship by descent under the old rules. So before the decree law, because your case still qualifies. The only exception would be, this is very important, and then I will explain you here, I have the text, an interesting recent court decision where a judge also made some first thought about the decree law. The only exception, of course, would be for the old people, also children born after the decree law. So all people born after March 27 of 2025. Of course, in this situation, potentially they can be, yes, under the new regulation, there is no escape on this. But if you were born before March 27, you can still apply, in our opinion, of course, you can still apply under the old regulation. So you can still file your application through the court system. We are talking, of course, about the court system because right now is the only way to challenge this type of cases. At the very end, I want to explain you a little important thing, because very recently, on the early of May 2025, there was a court in a process not handled by us, but handled by another colleague, attorney Marco Malone. We want to thank him for publishing the decision on public database for us lawyers. I mean, we use some database also for legal researchers. There was a very important decision that was made in the Tribunale, the court of Campobasso in the Molise region, early of May. Here, the case was, of course, talking about citizenship by descent under, of course, the old rulings. But there was an important thing that happened here, because here the counterparts, so the lawyers of the government, tried to say, hey, we have now the decree law 36, so these people cannot apply anymore. And it just says, no, you are wrong. You, government, you are wrong. And what is really important, once you very briefly read what the judge said in the decision, they says that what is important is the principle of the fact that the law cannot be retroactive. So a law now cannot change legal status made before the date of when the law is now in effect. So the law can start from this moment, regulating future situation from now for the future. Cannot be a law now regulating situation for the past. This is very important. Of course, this is a very clear principle. It's called Principio della irretroattività. So it's a really basic legal principle that says when a law is published, until there is a specific exceptional provision, the law starts from that moment to regulate all situations starting from that moment for the future. So cannot go back in the past, of course, because past situations are already regulated by old laws at that time. And so the judge says here, well, the applicants have the rights of Italian citizenship by descent. Why? Because they filed the application, of course, before the new decree law. And the judge says that the real interpretation that we can do to the decree law 36 of 2025 is the following. Only who is born from Italian parents after March 29 of 2025, so after the new decree law, can be the first generation under the new regulation. Who is born before March 29 has still the right, at the same time, of course, has still the right to claim Italian citizenship by descent. This legal precedent, a very fresh legal precedent, is already helpful for you to challenge your case. Because as we are saying, and everybody are saying in the legal community, right now you already have your rights of Italian citizenship by descent at the moment of your birth. You inherited your right by blood at the moment of your birth, so nobody can touch it. A new law now cannot touch the fact that you got your rights of citizenship at the moment of your birth. So at the very end, at the very conclusion, we still think that you don't need to give up. You don't need to be scared because they're trying to discourage people to not filing application. We will continue to fight for your rights, and you need to fight for your right. You don't need to give up. You need to continue fighting. We will continue to fighting. We are already filing many cases under the new, of course, provision. So of course we will keep you updated as soon as we have some decision, and we are pretty confident that we can have some good positive decision, and it's possible. We think that will happen. We will do that too, to try to go also in front of the Constitutional Court, because this new regulation is, in our opinion and common opinion, is completely, not completely, but in many ways can raise some constitutional concern. As always, if you have some comments, some questions, you can leave some comments below. We are happy to reply. Please, as always, keep in consideration that we cannot do consultation on YouTube via comments. It's impossible, but you need to book your consultation call. So you need to go to the website to contact us. There is a contact form specifically for booking consultation. This is the only way we have to analyze your case, to reply to your case, and having a face-to-face conversation about your case. Thank you so much, and we will keep you updated, of course, for all the future, of course, updates about this new regulation, and for all the other changes potentially that can be on the process. Again, thank you so much for your time, and see you on the next videos.